Hi guys, Jonathon Daily here, and we're going to talk to you today about answering an eviction complaint as a tenant and or filing a motion to determine rent or paying the court registry. So if you are a tenant who's been hit with an eviction complaint and are not sure how to respond or what to do in this situation, this is a video you want to stay tuned for. Let's get right into it. So you're a tenant, maybe there's been something going on with your landlord, there's some maintenance issues that haven't been addressed, and you weren't sure as to whether you should pay your rent or not. Ends up you didn't pay it, or you didn't pay it in full because you had to spend money on some repairs or a huge water bill, something like that. Boom, you're hit with a 3-day notice. Boom, you're hit with an eviction complaint. What do? Number one thing you gotta do in any type of lawsuit is file an answer. When you file an answer in an eviction suit in Florida, this is very important if you want to be 100% sure that you're going to get your day in court and get to address to the judge what's going on, your side of the story, why the eviction is wrongful, and why a final judgment should not be granted. You should file your answer and deposit the amount of rent that's either alleged in the complaint, deposit that amount into the court registry, or deposit the monthly rent amount. So if you've missed 1 month's rent for December 2025 and it's now January, you want to pay, if your rent was $1,500, then you want to pay $1,500 for December, and you want to pay another $1,500 for January if you're filing your answer in January. That way, you're almost guaranteeing your day in court that the judge is not just going to issue a final judgment of eviction against you, because as the statutes require, whenever you're alleging any defense other than non-payment, which the vast majority of the time, that's what's going on, because there's an issue with repairs. It's not just as simple as, oh, I paid and they're saying I didn't pay. There's a more complicated story going on. So if you want to guarantee that you're not waiving your rights to fight the eviction, pay the money into the court registry. Now, do you absolutely have to? No. There's a statute that we'll put on the screen here, and this statute says that you waive your rights to defend an eviction if you do not pay your rent that is due into the court registry, unless you file a motion to determine rent along with your answer. And this is saying that you disagree with the amount of rent being alleged, or you disagree that any rent is owed, and you're asking the judge to make a determination as to what, if any, amount of rent that is due be paid into the court registry. Now, an important caveat here. The statute also says that you need to attach evidence of what you think the rent should be. So it's not as simple as just filing a motion. Sometimes it is, but if you want to actually follow the statute so that you have a procedural argument, if you don't get your day in court, if you get a final judgment issued against you without having an actual evidentiary hearing, you need to attach evidence to this motion to determine rent, whether it's a screenshot of a bank account, bank statement, you sending money to the landlord, you agreeing that the rent should be lowered because of repairs, whatever it is, attach that evidence to the motion to determine rent if you want to ensure compliance with the statutory requirements. That being said, that is how you properly respond to an eviction complaint. Now, having done that, and having done this several times on behalf of people, it costs money to hire an attorney. It causes stress if you try to do it yourself. Either way, I'm not saying that you absolutely have to fight the eviction, but keep in mind the costs. You're going to be paying an attorney to file this motion on your behalf. You're going to be paying an attorney to go fight this in court. By the time you get your day in court, you get a hearing on your motion to determine rent, you're going to be $5 to $10 grand into attorney's fees. In 2026, there's no getting around. Legal representation is just as expensive as ever, and you're not going to find an attorney that's going to do it for free, most likely, and you're not going to find someone that's going to do it on contingency, anything like that. So keep in mind that it's always more beneficial to at least reach out and try to work out some sort of agreement with the landlord before you go this route. If you can do that, enter into a payment plan, make sure you get an email, especially if you're dealing with an attorney from the plaintiff landlord, get an email, some sort of agreement as to a payment plan, and that they will dismiss the eviction complaint if you comply. All that being said, if you can follow these proper procedural ways to respond to an eviction complaint, then you're at least going to be putting yourself in a much better position to negotiate some sort of stipulation with the landlord or the landlord's attorney, because at the end of the day, nobody wants to go to court to argue on these eviction cases, and nobody more than the judge wants to not be there listening to these arguments over an eviction. In St. Lucie County and many other, it depends on, every county's a little different. We've done a video on this. I encourage you to go watch it. Whoever the judge is, it really makes a big difference for these eviction cases. But one thing that is pretty common amongst all the judges is that they don't want to be there listening to the he said, she said, this happened, this didn't happen between a landlord and a tenant. They want both parties to be professional, get together and work out some sort of agreement so that the judge is not held responsible for making a decision as to who's in the right, who's in the wrong. And I will give this one last tidbit of information or my opinion on these evictions and contested evictions. Guys, the judges see so many tenants come in, and the vast majority of the times the tenants don't understand the law, or they're making an argument that doesn't make sense, and they're trying to say the place is not being well taken care of and the landlord's breached the warrant of habitability, and the judge is going to say, then why are you trying to fight to stay there? Leave. I know it's not as simple as that. I know most people may comment and say, well, this is my home. I live here. It's not so easy just to get up and leave and move. It costs $5,000 to $10,000 to get up and move. And you're correct. But the judges don't want to hear that, unfortunately. So keep in mind, when you're going to fight an eviction, you're going to be fighting an uphill battle. Now, no matter how much of a winning case you have. That being said, we have won cases for people in the past. We have gotten the attorney's fees and costs for people in the past. And if you have a case that you believe you're in the right and you're working with an absolutely unreasonable landlord and or property management company, then give us a call. We know the procedure. We know the process. We know what's best for you and when to reach an agreement and when not to. So give Daily Law a call, and we will be honest with you in our consultation as to whether it's going to be worth it or not. And we will be honest when it is a 50-50 case, because a lot of times it really is. It's that simple. So give us a call if you have any questions. If you need help filing a response, or if you want us to help draft it for you and give you advice, we can do that. As long as you sign the appropriate waivers, then we will do that. We will help you, and we will try to get you the representation you need. Thank you so much for watching this video.